Good evening, my name is David Frankel. I'm with the Native Hawaiian Legal Corporation. You're seeing a lot of outrage and anger, and there's many reasons for it, but I want to identify two. One is that the rules that you propose contain no substantive standards, no substantive criteria. In other words, they give the Public Land Development Corporation unfettered discretion to make decisions. Unfettered. And secondly, the PLDC has misled the public. In your August 24th, 2012 letter to the editor, Mr. Haraguchi, you said the PLDC, quote, is not exempt from laws meant to protect the environment. That is false. HRS 171C-19 provides that PLDC projects, quote, shall be exempt from all statutes, ordinances, charter provisions, and rules of any government agency relating to land use, zoning, and construction standards for subdivisions, development, and improvements of land. Here are some of the laws that PLDC is exempt from. Number one, HRS Chapter 205, the State Land Use Law. The Hawaii Supreme Court has ruled that Chapter 205, quote, Chapter 205 is a law relating to environmental quality. Chapter 205, the Land Use Law, has protected us from development above Kealakekua Bay on the Big Island. It's protected us from development at Oma. It's protected us from having an amusement park in Waianae. And yet, you have the authority now you're exempt from this law. And you're not including any substantive standards in your rules to prevent these kinds of bad developments from happening. Another law you're exempt from is HRS Chapter 205A, the Coastal Zone Management Act. The Hawaii Supreme Court has definitively ruled that this law is a comprehensive state regulatory scheme to protect the environment and resources of our shoreline area. This law has protected the Makai area, Makai of Na'alehu, from a massive development. It prevented fake lagoon, marina, by the Maunalani Resort on the Big Island. These laws have substantive components that protect natural resources and cultural resources. You don't replace them with any substantive standards in your rules. HRS Chapter 183C is a law that relates to the Conservation District and protects some of the most important natural and cultural resources in the state. The PLDC is exempt from this law. You're also exempt from zoning ordinances. The purpose of county zoning ordinances, according to the Hawaii Supreme Court in the Dalton case, is, quote, to prevent the deterioration of our environment. Zoning laws have protected areas, for example, like Punakahau, which has many natural and cultural resources that we know Neil Abercrombie wants to develop, and which we were able to successfully prevent development from a few years ago. And yet your rules would allow you unfettered discretion to allow development there. Finally, PLDC is exempt from all the subdivision ordinances and rules. Subdivision ordinances are written in a way to protect both built infrastructure and natural infrastructure, drainage, coastal water quality, flooding, and you're exempt entirely from those requirements. Now, not only do you adversely affect natural resources and cultural resources, but these laws that you're exempt from play a critical role in protecting traditional customary Native Hawaiian practices. By being exempt from the laws and not having any substantive standards, you put these at risk. I'd like to say to you, Mr. Isla, you're finally in a position of authority to do some real good. You will never have a position with as much authority to do good as you have now. Use it wisely. Thank you.